Alright, Title 49, Subtitle B. Other regulations relating to transportation, Chapter 12, Transportation Security Administration, Department of Homeland Security. Subchapter A, Administration Procedural Rules, Part 1500, Applicability Terms Abbreviations. 1501, Applicability. The chapter of the subchapter in this part apply with all matters related to the Transportation Security Administration. 1503, the terms abbreviation used for this chapter. Used in this chapter, administrator means the associate Secretary of Homeland Security, Transportation Security Administrator, who is the highest ranking TSA or Transportation Security Administration official of his or her designee. The administrator also means the Undersecretary with the Transportation Secretary identified. Authorized representative means an individual who is not directly a person or the person regulated under this title will be authorized to act on the person's behalf of the perform measures required under the Transportation Security Regulation or Transportation Security Administration Security Program. For the purpose of the subchapter of the term authorized representative include agents, contractors, subcontractor, employees of the same. Bus means any several types of motor vehicles used, the public and private entry to provide a transportation service for passengers. Bus transit means a public transportation system provided with a transportation service not limiting to morning, evening, peak travel time. Primary purpose of moving the passenger between bus stops. Often multiple connection bus transit system does not become a commuter bus system, even if the primary purpose of the transportation commuter of the term does not include the tourist, scenic, historic excursion operation. Commuter bus system means a system providing passenger service primarily during the morning, evening, peak periods between the urban area and more distant outlying communities in a greater metropolitan area. Terms does not include tourist, scenic, historic, or excursion operations. Commuter passenger transportation service means a train commuter is defined in Title 49, 238.5. It includes service provided with a diesel electric powered locomotive with a railroad passenger car to serve urban area, suburbs, more distant outlying communities, and greater metropolitan area. Commuter passenger train service part of the general railroad system transportation regardless of whether the physical connectivity to the other railroads. DHS means the Department of Homeland Security, any Directorate Bureau, other component with the Department of Homeland Security, including the United States Coast Guard. DOT means the Department of Transportation, any of the operating administration, any office within the Department of Transportation. Fixed route service means the provisions of the transportation service by private entities operated along a prescribed route according with a fixed schedule. General railroad system of transportation means the network standard gauge track over which the goods may be transported throughout the nation. Passengers may travel between cities and with metropolitan suburban areas defined. Appendix A, Title 49, CFR 209. Hazardous material means hazardous materials defined in Title 49, 171.8. Heavy rail transit means service provided with a self-propelled electrical rail car trying typical drawing power of the third rail operating separate right-of-ways with multiple cars, also referred to as subways, metros, and regional rail. Host railroad means a railroad that has effective control of the segment of the track and improvised explosive device. Means a device fabricated in an improvised manner that incorporates explosive, destructive, lethal, noxious, pyrotechnic, incendiary chemicals in its design. Generally includes a power supply, switch, or timer, detonator, or an initiator. Intercity passenger trains means both the train long distance intercity passenger train, short distance intercity passengers defined in Title 49 CFR 238.5. Light rail transit means the service provided with self-propelled electrical rail cars, typical drawing power from overhead wire, operating with either with exclusive or non-exclusive right-of-way in a single or multiple cars. Short distance trips or frequent stops is referred to as streetcars, trolleys, and trams. Motor vehicle means a vehicle with a machine and tractor, trailer, semi-trailer propelled by or drawn by mechanical power used upon highway transportation passengers or property or any combination thereof that does not include the vehicle, locomotive of the car operated exclusively on rails, trolley, bus operated by electrical power derived from a fixed overhead wire furnishing local passenger transportation similar to street railway service. Over-the-road bus means a bus characterized as an elevated passenger deck located over the baggage compartment. Owner and operator means any person that owns and maintains, operates, control any of the transportation infrastructure asset facility system regulated under this title, including airport operator, aircraft operator, foreign air carrier, indirect air carrier, certified cargo screening facility, flight school within the meaning of Title 49 CFR 1552(1)(b). Motor vehicle public transportation agency, railroad carrier for the purpose of maritime facility or vessel owner operator that has the same meaning as defined in Title 303 CFR 101-105. Passenger rail car means a rolling equipment intended to provide transportation for the members of the general public, including the self-propelled rail car designed carry passengers, baggage, mail, and express. The term includes all rail passenger coach, cab car, multiple unit locomotive, and context articulated equipment. Passenger rail car means the segment of the railroad rolling equipment located between two trucks. The term does not include the private rail car. Passenger railroad carrier means a railroad carrier that provides transportation to a person other than an employee, contractor, the person riding the equipment to observe the monitoring railroad operations, but railroad intercity passenger service and commuter, other short roll passenger service in the metropolitan suburban area. Passenger train means a train that transports available to transport members of the general public. Person means individual, corporation, company, association, firm, business, partnership, the joint society, joint stock company, governmental authority. It includes trustee, receiver, assigner, successor, and similar representatives of any of them. Private rail car means a rail rolling equipment that is used only for the excursion, recreational, private transportation purpose. A private rail car is not a passenger rail car. Public transportation means transportation provided by the general public, a regular, continuing, general, specifically transportation vehicle owned, operated by the public transportation agency, included one of the following types of passenger transportation. One, intercity commuter passenger train service other than short-haul railroad passenger service metropolitan suburban area by Title 49 CFR 2001021. 2, heavy light rail transit service whether on our general railroad system transportation. 3, any automated guide cable car, including plane, funicular, monorail system, bus transit, commuter bus service. Public transportation is any public owned or operated to provide with a regular continuing public transportation. Railroad has a materials receiver, means an owner and operator with a fixed facility that has a physical connection. General railroad system transportation receives and unloads the transport commerce by one or more categories, quantities of the rail security sensitive material identified in Title 49 and 1580.3. But does not include owner and operator of the facility, owner, operator, department, agency, instrumental of the federal government. Railroad hazard material shipper means owner and operator of the fixed site facility that has physical connection with the general railroad system. Transportation offers define the definition of the person who offers an offerer, and Title 49 CFR 171.8 provides a load of transportation rail one or more categories, quantities of rail security sensitive materials as identified in Title 49 CFR 1583. Does not include owner and operative facility, owner, operated department, agency, instrumental with the federal government. Rail secure area means a secure location identified with all rail hazard material shippers and rail hazard material receivers where security related public pre-transportation transportation functions performed in rail cars contain categories, quantities of rail security sensitive material are prepared, loaded, stored, and or unloaded. Rail transit facility means a rail transit station, terminal location, rail transit infrastructure, assets, store, command, control, operation, perform, maintenances, perform. Terms also include rail yards, crew management centers, dispatching centers, transportation terminal stations, fueling centers, and telecommunication centers. Rail transit or rail fixed guided way system means a light, heavy, rapid rail system on a rail, included plane, funicular, cable car, trolley, automated guide way that traditionally does not operate on the track but is part of the general railroad system. Transportation railroad carrier means an owner out provide railroad transportation. Railroad transportation means 1, any form of non-highway ground transportation that runs on rails, electromagnetic guideways, including 1, commuter or other than short-haul railroad passenger service transportation, metropolitan suburban area, and 2, high-speed ground transportation that connect metropolitan areas with regard whether these systems use new technology associated with traditional railroads. And 2, such terms include railway transportation operating on a track, park, general railroad system transportation. Does not include rail transport operation in urban area that are not connected to general railroad system of transportation. Our record includes any means of the information preserved irrespective of the format included: book, paper, drawing, map, recording, tape, film, photograph, machine-readable material, any information stored in electronic format. The term records all and includes and draft and proposed recommended changes to any record. Sensitive security information means information described and much managed in accordance with Title 49 CFR 1520. State means the state of the United States. In District of Columbia. Tourist Unique Historic Excursion Operation means a railroad bus operation that carries passenger, often used antiquated equipment with conveyance of the passenger to the particular destination. The principal purpose of the train bus movement is with the new passenger equipment to demonstrate purpose non-tourist scenic historic excursion operation. Transit means mass transportation conveyance with provides regular continual general Special transportation public does not include a school bus, characterizing transportation, rail transit, maker with the on and off the general railroad system and transportation. Transportation or transport meaning the movement of property, including loading, unloading, storage, transportation, transport includes the movement of the people boarding, disembarking, incidental to the movement. Transportation facility means a location within the transportation, cargo, equipment, and infrastructure. The assets are stored and equipment to transfer between conveyances and modes of the transportation, command, control, operation, or performed, or maintenance operation performed. Terms also include, but not limited to, passenger trains. Terminals includes any fixed facility in which passengers are picked up and discharged. Vehicle storing, building yards, crew management centers, dispatching centers, fueling centers, and telecommunication centers. Transportation security equipment and systems means items both integrated into a system standalone used by owners operated to enhance capability to detect, prevent, respond to threat incident, including but not limited to surveillance, explosive detection, radiological detection, intrusion detection, motion detection, security screening. Alright, Transportation Security Regulation, meaning with the Regulation of Transportation Security Administration, Title 49, Code of Federal Regulation, Chapter 12, which includes Parts 1500 through 1699. Transportation Security Sensitive Material means hazardous material identified in Title 49 CFR 172-800B. TSE means Transportation Security Administration, United States. Geographical sense meaning with the state of the United States, District of Columbia, the territories possession of the United States, including territorial sea and overlaying airspace. Vulnerability assessment includes any review, audit, or other examination of security of the transportation system and infrastructure as of the transportation-related automated system of the network, determine vulnerability, unlawful interference, whether during conception, planning, design, construction, operation, decommissioning phase of vulnerability assessment, includes methodology of the assessment and the result of the assessment, any proposed recommended of the directed action countermeasures to address security concerns. 1505 Rules of Construction. In this chapter, unless context requires otherwise, words importing singular include plural, words importing plural include singular, words importing masculine, genders include feminine. In this chapter, the word must is used as an imperative sense, may is used with a permissive sense of the state of authority, the permission to do act prescribed. Words no person may or a person may not means that no person is required, authorized, or permitted to do the act prescribed. And 3 includes, may includes, but not unlimited to. Alright, that was 1500 applicability in terms of preservation, terms and abbreviations. Alright, 1502 organization function procedures. 1502-1 responsibility of the administrator responsible for planning, direction, control of the transportation security administration for the security of all modes transportation administrator responsible who's carrying out chapter 449 Title 49 U.S. Standard Code relating to civil aviation security related to the development and activity security responsibility other modes of the transportation except for the Department of Transportation. Deputy Administrator, First Assistant Administrator for the purpose of the Federal Vacancy Reforms Act of 1998 and shall event with the Administrator that desires, resigns, or is otherwise unable to perform function duties of the office serving the acting administrator subject to limitation Federal Vacancy Reform Act of 1998 in the event of absentee disability with both the administrator, the deputy administrator, the official of the designated with the Transportation Security Administration internal order on succession shall serve as the acting deputy administrator shall perform the duties of the administrator except for any of the non-delegated, delegable, statutory, or other regulatory duties. Alright, this one's actually pretty long. We're going to go for it anyways. 1503 Investigative Enforcement Procedures, Subpart A, General. 1503-1 Scope. The part provides information, transportation, security, administration, investigative enforcement procedures. 1503-3 Reports on public security problems, deficiencies, vulnerabilities. Section prescribes the reporting mechanism the person may use in order to obtain a receipt for the report. Transportation Security Administration regarding transportation-related security problems, deficiencies, and vulnerabilities. A. Person who reported to TSA with a transportation security related problem, deficiency, vulnerability include the security, aviation, commercial motor vehicle, the maritime pipeline, any of the mode of the public transportation, railroad transportation, will receive the receipt of the report if provided with a valid contact information report through one of the following: U.S. Mail Transportation Security Administration, Headquarters, TSA 2, attention, Title 49 CFR 15033, report 601 South 12th Street, Arlington, Virginia 20598 6002. Internet TSA.gov. Contact select security issues or toll free at 1-866-289-9673. Report submitted with mail will be received with through the mail. Report submitted by the internet will receive the email. Receipt with the report submitted by phone will receive the call identifier number. Link to TSA documents held in according to published records scheduled to obtain on the public paper. Copy of the reports provided with the phone with the person who made the report. Otherwise authorized representative must in contact TSA to address the identified A1 of the section within the period provided with the identified number. C with the TSA with a review of the considered information provided. Any report submitted under this section may take an appropriate step to address the problem of deficiency vulnerability identified. D. Nothing in this section will leave the person separate over the obligation to report the information to TSA under any of the provisions of the Title Security Program, Security Directive, or to another government agency under the oath of other law. Immediate emergency security and safety precautions should be reported with the appropriate local emergency service operators such as telephoning 911. Alleged waste, fraud, abuse, and TSA programs should be reported to the Department of Homeland Security Inspector General, telephone number 1-800-323-8603, or email dhsoig hotline dhs.gov. Subpart B, Scope and Investigation Enforcement and Procedures, 1503-101, TSA Requirements, Investigative Enforcement, proceed with the parts of the applied TSA Investigation Enforcement Violation TSA Requirements. For the purpose of the Department, TSA requirements mean the following statutory provision, regulation prescribed, otherwise issued under any of the provisions of the provision Title 49 U.S. Standard Code Administrator by the Administrator, Title 46 U.S. Standard Code, Chapter 701, and provisions of Public Law 110-53, not codified in the Title 49 U.S. Standard Code Administrator by the Administrator. Alright, 1503-103, terms used in this part, with addition with the term 1503, with the chapter following with the definition applied with this part. Administrative law judge or LAG, the appointed for certain provisions of Title 5 U.S. Standard Code 3105. Agency attorney meaning with the deputy chief of counsel for the enforcement over an attorney that he or she designates the agency with the attorney will not include 1. An attorney office, chief counsel would divide with the TSA with the decision maker, with the general, with the initial decision, with any of the people with the TSA division, or 2. Any attorney supervised with a civil liability action by a person who provides such advice to the TSA decision maker in that action's faculty related action. Attorney means any of the person eligible to practical law with the members of the good standing with the bar, with the highest court, with the state, with the provision, possession, territory, commonwealth of the United States, with the or the District of Columbia. Does not any other suspending, enjoining, restraining, with the disbarring, with the otherwise restricting him or her practice the law. Enforcement investigative reports, or EIRs, are written reports provided by the Transportation Security Inspector over the authorized agency official, relating the result of the inspection investigator with the violation of TSA requirements include the copy of the relevant evidence. Mail includes first class U.S. mail, so with U.S. certified mail or U.S. registered mail party means a respondent to the TSA. Personal delivery, whose hand delivery of the contract express messenger service included overnight express courier service. Personal delivery does not include the use of government inter-officer mail services. Pleading means the complaint answer motion with any amendment with the documents permitted with the under the subpart with any of the other written assessment submission with the administrative law judge and party during the course of the hearing procedure. Properly addressed means with the document with the show with the address contained with the agency record with the recent business other administrative submitted with the person any other object document provided under this part. Any other address obtained with the other reasonable available means. Public transportation means a publicly owned operated public transportation eligible to receive federal assistance under Title 49 U.S. Standard Code Chapter 53. Respondent means a person named in notice of proposed civil penalty, first notice of the proposed civil penalty in order or a complaint. Transportation Security Administration decision maker means with the administrator acting capacity with the decision maker on the appeal or any person with the administrator with the delegate with administrator decision making authority. Civil penalty action authorized in this part. TSA decision maker is official authorized to issue final decision order administrator within civil penalty action. Subpart C, investigative procedures. 201. Any person who knows of the violation of TSA requirements should report with the appropriate personnel of any TSA office. The TSA will review each report made under the subsection together with any other information TSA may have the relevant of the matter reported to determine the appropriate response with including additional investigation, administrative, or legal enforcement action. 203. Investigation. General administrative, the designated official may conduct investigative, hold hearings, issue, suspend, and record production of relevant document records and property taken evidence for the deposition, delegation of authority. For the purpose of investigation, alleged violations of the TSA requirement, administrative authority may be exercised over the agency, various offices of the matters within the respective areas. All routine investigations, compulsory process, Title 49 U.S. Standard Code 46104, invoked with the administrative authority of the delegate of the Chief of the Council, each of the Deputy Chief of the Council, and Consolation Officer of the Chief of the Council, Assistant Administrator of the Secretary Operations, Assistant Administrator of the Transportation, Secretary Network Management, Assistant Administrator of the Inspection, Assistant Administrator of the Law Enforcement Director for the Federal Air Marshal Service, and Special Agent in charge of each of the Federal Security Director. 1503-205. Records, documents, and reports. Each record, document, and report with the regulation of the Transportation Security Administration required with the maintained exhibit submitted to the administrator may be even an investigation conducted by the administrator except to the extent to the use may be specifically limited and prohibited by the section above with the requirements. Record, documents, reports may be used in any civil penalty action or other legal proceedings. Subpart D. Non-civil penalty enforcement. A. If the Transportation Security Administration has determined the violation, alleged violation, TSA requirement does not include in the assessment civil penalty, as appropriate official of the TSA may take an administrative action disposition. In the case of administrative action of the section does not include constitute formal injunction of the matter, but it may take an issue with the alleged violator a written notice of receipt recites available fact with the information for the incident of the condition and indicate that it may have been a violation or a letter of correction confirms TSA decision of the matter of the state of the necessary corrective action with the alleged violator has taken agreed to take it if the agreed corrective action is not fully completed. Legal enforcement action may be taken with the issuing of the warning notice of the letter of correction is not subject to appeal under this part. D. In the case of the public transportation agency determined violation TSA requirements appropriate TSA official will seek correction violation through a written notice of non-compliance with the public transportation agency given the public transportation agency the reasonable opportunity to correct violation proposed alternate means of complying with acceptable TSA. TSA will not make legal enforcement agencies against public transportation agency under subpart E unless they provide with a notice for the non-compliance described in paragraph D of the section. When the public transportation agency fails to correct violation proposed with the alternate means of the compliance acceptable to TSA, which within the time frame provided with the notice, the TSA will not initiate civil enforcement for violation administrative of the procedural requirements pertaining to the application for an expenditure of the funds awarded pursuant to the Transportation Security Grant Programs under Public Law 110-53. Subpart E, assessment of civil penalties. TSA 1503-401, maximum penalty amounts. TSA may assess civil penalties not exceeding the following amounts against the person in violation of TSA requirements in general, except for the provided in subpart in paragraph C within this section case violation Title 49 U.S. Standard Code and Title 46 U.S. Standard Code, Chapter 701, regulations prescribed order to issue any of the provisions. TSA may impose civil penalty following amount. Violations occurred with the line before November 2nd, 2015. $10,000 per violation up to with a total of $50,000 per civil penalty action. In the case of the individual small business concern, small business concern is defined in subsection 3, Small Business Act, Title 15, U.S. Standard Code 632. Violations occurred with the November 2nd, 2015, $13,785 per violation, up to the total of $68,928 per civil penalty action, case of the individual or small business concern. For the violation occurred on or before November 2nd, 2015, $10,000 per violation, up to a total of $400,000 per civil penalty action. In case any other person violation of the occurred after November 2nd, 2015, $13,785 per violation, up to a total of $551,417 per civil penalty action. In case of any other person. Or C, certain aviation-related violation, case of the violation, Title 49 U.S. Standard Code, Chapter 449, or Title 49 U.S. Standard Code 46302 and 46303, regulations prescribed and order issued under these provisions. TSA may impose civil penalty on the following amounts. For violation occurred with the bond before November 2nd, 2015, $10,000 per innovation with up to $50,000 civil penalty application in case of the individual or small business concern. For violation occurred within November 2nd in 2015, after $16,108 per violation, up to a total of $80,540 per civil penalty action in case of the individual except for the airman serving as an airman or small business concern. 2. For violation occurred within November 2nd of 2015, $10,000 per violation, up to the total of $400,000 per civil penalty action in case of any other person not operating an aircraft for the transportation of passengers or property. For the compensation for violation occurred after November 2nd, 2015, $16,108 for violation, up to $6,443 per civil penalty action case with any other person not operating an aircraft for the transportation of passenger property for the compensation. 3. Violations of the occurred with the bond before November 2nd, 2015, $25,000 per violation, and total of $400,000 per civil penalty action case with the person operating the aircraft with the transportation passenger property for the compensation. For violation occurred after November 2nd, 2015, $40,272 per violation, up to a total $644,343 per civil action case with the person except for the individual serving an airman operating aircraft with the transportation passenger property for the compensation. 1503-403 Delegation of Authority. Administrative delegates the following authority: the Chief Counsel, the Deputy Chief of the Council, enforcement with the authority to redelegate is necessary to initiate excess civil penalties under Title 49 U.S. Standard Code 114-46301, subpart of the violation TSA requirement. B. To compromise civil penalty initiated under subpart C, refer to the Attorney General of the United States, delegate the Attorney General in the collection of civil penalties. 1503-405 injunctions, wherever determined by the person engaged about to engage in any of the practice of the consult with the TSA requirement. Chief Counsel with the Deputy Chief of the Council for the enforcement may request the Attorney General of the United States with the delegate with the Attorney General to bring an action with the appropriate to the United States with the district court such relief as is necessary and appropriate, including mandatory prohibitive injunction relief with internal equatable relief and punitive damages provided in Title 49 U.S. Standard Code 114 and 46107. 1503-407 the military personnel report made under the part indicate for the performing official due for the member of the armed service civilian employed with the Department of Defense subject to the Uniform Code of Military Justice, Title 10 U.S. Standard Code, Chapter 47 that has violated TSA requirements. The agency official will send a copy of the report appropriate to military authority for such disciplinary actions as authority considered appropriate in report of the administrative thereon. 1503-409 service documents. General, the section governs service documents required to be made under the Part B type of service person who serve the documents, personal delivery. 2. Mail. 3. Electronic mail, fashionable transmission consented with the written with the person service except with such service does not affect the party making service receive credible information indicating attempted service does not reach the person to be served. C. If the parts playing the other part of the hearing the occurrence course of hearing proceeding, the electronic mail fast mail transmission party makes service must file enforcement document clerk copy of the consent of the receiving party except for the method of the service. D. The date for the day of the service will be the day of the personal delivery. 2. The mail date stated with the certified service of the date shown on the postmark. There is no certificate of service. Other mailing date shown by other evidence that there is no certificate of service or postmark. 3. Send electronic mail fast mail data transmission. E. The valid service document served by the person or person delivery with the properly addressed was sent in accordance with the part with the return was not claim that was refused deemed to have then served in accordance with the Department of Service will be considered valid as of the date with the time of the document with the deposited with the contractor or express messenger of the document was made with the personal delivery of the document was attempted to refuse. After the presumption of service, there was a presumption of service where a party or person who, with the customarily received the mail, received the ordinary course of business, either person residence of the person's principal per plan of business acknowledgement, received the document. G. The additional time after service of the mail, move the party of the right of the duly act to make it and respond with the prescribed period after service of the mail with the date concerned and after service by mail 5 days by added prescribed period. Alright, 8. Serve the documents filled with the enforcement document in person must serve any of the document with the enforcement document in each party with the adjunction law judge, chief of the adjunction law judge, if no judge has been assigned, proceed with the time of the following service with the parties of the attorney with the record parties designated representative of the service on the party. I certificate of service. Each party must attach a certificate of service attached document intended for the filing with an enforcement docket clerk. Certificate of service consists of the statement, the date of the signed in person with effect of service, the name of the person served, and the method of the duty in which each person will serve the day of the service made. J. Service by the junction law judge. Junction law judge must serve with a copy of each document he or she issues, including but not limited to notice of the pre-hearing conference for the hearings, rules, or motions, decisions, or orders upon each party of the proceeding. 1503-411, the computation of the time in the section apply with any with a period of time prescribed allowed by the part notified by the order of the junction law judge. B. The date of the enactment event with the default, after which designated time period begins to run in, if it is not included with the computation time under the subpart. C. Last day of the time period included with the computation time and left the Saturday, Sunday with the legal holiday of the enforcement of the document officially closed. Latest day of the time period of Saturday, Sunday, the legal holiday with the daily enforcement document is officially closed. The time period runs until the end of the next day, but it is not a Saturday, Sunday, legal holiday day with the enforcement document officially closed. 1503-413, notice of the proposed civil penalty issued with the TSA, but it may initiate a civil penalty action under the sections by serving the notice of the proposed civil penalty with the person charged violation of the TSA requirement. TSA will serve the notice of the proposed civil penalty, including charge of violation of the president of the corporation company charged with the violation of the representative or employee previously identified with the writing of the TSA with the designated receiver such service as a corporation company with the made designated with the TSA and another person to receive service saying subsequent to document civil penalty. The action content for the notice of the proposed civil penalty contained with the statement of facts alleged with the statute, regulation, or other alleged violation amount with the proposed civil penalty and certificate of service C with the respondent with no later than 30 days after the receipt of the notice proposed civil penalty, and the person charged violation may take only one of the following options: submit with the check, certified check with the make and an order with the amount with the proposed civil penalty made with the payable to Transportation Security Administration, just specified with the notice of proposed civil penalty. Make payment electric with the pay.gov. Submit with the agency attorney the issue of the notice of proposed civil penalty. One of the following: 1. Written request of the TSA with the ordering assessing civil penalty amount stated with the notice of the proposed civil penalty without further notice, in which case the person waived the right to request formal hearing. Payment is due within 30 days of the receipt of the order. 2. With the written information for the other evidence of the included with the document witness statement that demonstrated the violation regulation did not occur as alleged and that the proposed penalty is not warranted, but the circumstance. 3. The written request for the review of the proposed civil penalty amount, request for reduction together with the document supporting reduction proposed civil penalty, which reflect current physical and inability to pay records showing the payments of the proposed civil penalty would prevent the person from continuing the business. 4. Written request and formal conference for the day with the determined by the agency with the attorney to discover the matter with the agency with the attorney with the submit supporting evidence of the information agency the attorney before day with the informal conference. 3. Submit an agency attorney with the TSA enforcement document clerk with a written request for a formal hearing before an injunction law judge in accordance with the subpart G with this part. TSA enforcement docket clerk is currently located in the United States Coast Guard ALG Docketing Center, 40 South Gay Street, room 412, Baltimore, Maryland, 21202-4022, and location chain with the TSA will provide notice to chain with the notice of the Federal Register. 1503-415, request for the proper portion of the Enforcement Investigation Report, or EIR. Upon receipt of the notice, proposed civil penalty person change charged with the violation. TSA requirement the representative designated with the writing in person may request the changes for the internal attorney with the reissue with the notice of the proposed civil penalty proportion with the relevant enforcement investigation report and are not privileged under the deliberate process of the attorney work product attorney client privileges. This information provided with the sole purpose of providing information necessary to prepare with the response to the allegation contained with the notice of the proposed civil penalty. Sensitive security information SSI contained within the enforcement investigative report may be released pursuant to Title 49 CFR Part 1520. Important information release under this section is not produced under the Freedom of the Information Act. B. With any person not listed in the paragraph A with the checks and interested in obtaining a copy of the enforcement investigation report must submit the Freedom of Information Act request pursuant to Title 5 U.S. Standard Code 552, Title 49 CFR Part 7, and any of the applicable DHS regulation portion of the enforcement investigation report may exempt from disclosure pursuant to the Freedom of Information Act and 1503-417. Final notice of proposed civil penalty order issued for the TSA with the may issue the notice of the proposed civil penalty or with the final notice of the order of the person changed for the violation following circumstances Person has failed to respond with a notice of the proposed civil penalty under 30 days to receive with a notice of the proposed request. Person requested the informal conformance with 1503.413 C2 of the tentative of the conference for the continuation of the conference to provide agency of attorney with a written request showing the good call for the rescheduling the informal conference for the specified alternate date. The parties that participate with the informal conference and other informal proceedings are provided in statute 1503.413 C2 of the parties who have not agreed with the compromise with the action with the agency of the attorney have not agreed to withdraw with the notice of the proposed civil penalty. B, with the content of the final notice order will contain with the statement of the facts alleged to the law, alleged violation by the respondent, the amount of the proposed civil penalty. The final notice and the order may reflect with the modified with the allegation of the proposed civil penalty as all information submitted to the agency attorney during the informal proceedings under section 1503.413 C2. Or 1503.419, ordering assessing civil penalty issuance pursuant to the statement of the settlement. TSA will issue the order assessing civil penalty if the parties that participate in the informal conference or their informal proceed with the statute 1503.413 C2 and agree with the civil penalty amount with a compromise of the matter in the case of the person waive the right to require the formal hearing paid to do within 30 days of the order. B, automatic issue of the final notice and order automatically converts the order assessing civil penalty of the person charged with the violation submitted with the certified check with the money order and amount will reflect with the final notice order. The Transportation Security Administrative address the specified final notice order makes such payment at administrative.pay.gov. The person failed to respond with the final notice order for the request of the formal hearing within 15 days of the receipt of the notice. 1503.421, streamline civil penalty procedure to give it an certain security violation. Notice of violation. TSA with the agency discretion may initiate civil penalty action through the issue of the notice of violation. Violation described in the section otherwise provided with the administrator with the TSA may issue with the notice of violation of an individual who violated the TSA requirement by presenting weapons with an explosive at the incendiary over the screen over the airport with a check badge where the amount proposed the civil penalty is less than $5,000. B, contacts known of violation contained with the statement of the charged amount with the proposed civil penalty and offers settle with the matter with lesser specified penalty amount. C, respond no later than 30 days of the receipt of the violation. The individual charged with the violation must respond with the TSA may take one or only one for the following option. 1, submit the certified check with the money or with the lesser with the specified with the penalty amount with the notice violation paid payable to the Transportation Security Administration same with the address specified. Notice of violation of such payment that collection only through payment to Gov. 2, submit with the office with the identify with the notice violation one of the following written information of the evidence include the document written statement that demonstrates the violation regulations did not occur with the alleged act with the proposed penalty with not warranted by circumstances. 2, with the written request to reduce the proposed civil penalty amount with the request for the reduction given the document supporting the reduction of proposed civil penalty which reflect with the current financial inability to pay with the record showing with the abatement of the proposed civil penalty would record prevent the person from continuing in business. 3, the written request for the informal conference with David determined by the agency official with the discuss. And there with the agency official with the in support with the supporting evidence of the information agency official with the before with the date of the informal conference. 3, the submit with the office with the identified with the notice violation from the TSA enforcement document. The clerk with the written request for the formal hearing with the junction law judge in accordance with the subpart GA. Request of the formal hearing with the junction law judge must be submitted with the address provided within statute 1503.413 C3. D, final notice of violation civil penalty assessment order. The TSA may issue the final notice of violation civil penalty assessment order in the receipt of any of the notice of violation following circumstance. 1, the individual has failed to respond with the notice of violation within 30 days without the receipt of the notice. 2, the individual requested the informal conference of 1503.421 C2 3, but failed to attend with the conference. Continue with the conference to provide with the agency with the written request to show good call for the rescheduling informal conference for the alternate date. 3 of the parties have participated in formal conference with the other informal proceed with the provided in 1503.421 C2 with the party that has not agreed with the compromise with the action agency official that has not agreed to withdraw with the notice of violation. E, the orders of the assessing civil penalty final notice of the order automatically converts to the order of the assessing civil penalty if one individual charged with the violation submitted the certified check with the money order with the amount with the flag with the final notice order of the Transportation Security Administrative draft specified with the final notice order to make such payment electronically through pay.gov. The individual failed to respond with the final notice order required for the formal hearing within 15 days of the receipt of the notice of the delegation with the authority administrative of the Title 49 U.S. Code 46301 to issue with the negotiated civil penalty action with the section delegated with the system administrator. The security option with the authority may further delegate. 1503, 423, consent orders issued at any time of the before the issue of the order is set with civil penalty on support of the agency with the joint person subject to notice of the proposed civil penalty agency, the official and person subject with the notice of violation may agree with the disposal of any of the case of the issue with consent with the order of the TSA. B. The content consent of the order contained with the following admission of all the jurisdictional facts. 2. With the admission with the agreed upon all allegations. 3. A statement of the law violated. 4. Finding of the violation. 5. With express waiver of the right to further procedural steps. All rights administered with judicial review. 1503, 425, the compromise over the issue of the any time of the before the issue of the order assessing civil penalty subpart of the agency for the term person sub with the notice of the proposed civil agency for the official person sub with the notice of the violation may agree with the disposal of the case of the issue with the compromise order of the TSA with the contents of the compromise order contained with all jurisdictional facts allegations. All statements of the persons agree to pay the civil penalty specified for. The statement of the TSA makes no finding of the violation. 5. The statement of the compromise order will not be used the evidence to provide violation with any subsequent civil penalty proceedings. 1503, 427 with the request of the formal hearing. Generally, the respondent may request the formal hearing pursuant to 1503, 413C3 and 1503, 421C3 with the according with the procedures of the subpart G with the part of the filing and the request of the formal hearing does not guarantee for the person the opportunity to appear before a junction law judge the person before the junction law judge may issue the initial decision to disrupt the unit of the order of the result of the case prior to the commencement of the formal hearing. B. The form of the person submitting the request for the hearing must state with the sign of the request for the must of the include with his or her of the current address of the request of the hearing must be typewritten with intelligibly handwritten. She submitted with the request of the person request for the hearing must file with a written request for the hearing with an enforcement document in accordance with the 1503, 421 must serve with a copy of the request for the agency, the attorney, the other agency, officer with the notice of the proposed civil penalty notice of violation accepted with any other importance from 1503, 429. 1503, 429, filing document and enforcement document clerk. General section governing the filing of the documents enforcement document clerk required under this part with the types of the service but not filed with the document and enforcement document clerk delivering 2 copies of the document is filed by personal delivery of the mail of the United States Coast Guard or junction law judge of the docketing some of the intent with the enforcement document clerk address specified in 1503, 413C3 but electronic mail a junction law judge docket ALGA Bolt, U.S. Coast Guard Mill. Email address TSA will provide a notice of change with the notice of the Federal Register with the 3 of the fast mail transmission of 410 962 1746. The number chain with the TSA provide with the notice of the chain with the notice of the Federal Register. C with the content. Unless otherwise specified within this chapter, in this part of each of the document must contain the short and plain with the statement of the fact for the supporting of the person's position with a brief statement of the action required for the document. Each of the document must contain written and legally handwritten. Date of filing, the date of filing, filed with the date of the personal delivery, if the mail with the mailing document, date, state with the certificate, states, serve with the date, show with the postmark with the no certificate, serve with the other mailing date, show with the evidence that there's no certificate, serve with the postmark, 3, the sent, electronic mail, fast mail transmission, data transmission, the serve with the document filled with the enforcement document, the person must serve with a copy with the name of the document filed with the enforcement document. Each party a junction law judge with the chief of the junction law judge, if no judge has been assigned with the proceeding of the fine of the following, serve of the party's attorney, of the record persons designated representative in service of the party. 4, 1503, 431, certification of the documents. General of the section governs each of the document filing with the enforcement document clerk over the under this part. Signature required by the attorney of the record of the party representative may sign each of the document intended for the filing with the enforcement document clerk served by the junction law judge of the TSA with the decision maker on the appeal or each party. C. Effective signing of the document, but signing of the document attorney of the record party with the parties representative certified that he or she with the brief of the document based on the responsible inquiry with the best of the person's knowledge and information relieved of the document. 1. Consider the rules and part of the 2 of the warrant existing law, good faith with the non-frivolous of the argument exists with the extension of the modification reversal of the existing law. 3. Not unreasonable with unduly burdensome, the expense with the not made with the harassing with the person not made with the cause necessary delay with the made cover the needless increase of the cost of the proceedings for any other purpose of the purpose and proper purpose of the support of the evidence, even the denial of factual contentions or warranted of the evidence. D. Sanctions on motion of party junction law judge of the TSA with the decision maker found with the attorney with the record with the party representative that has signed a document of violation with the section of the junction law judge of the TSA. The decision maker has an appropriate to do the following actions. 1. State with the pleading sign with the violation of section 2. Strike with the request for the discover the response sign with the violation section precluded further discovery given by the party. 3. Deny the motion requested in the sign violation of section. E. With exclude the Document signed with violation section with a record 5 of the dismiss with the interlucenary appeal with a procedure of further appeal on the issue with the party will fill appeal with the initial decision as entered into the record. 6. The dismiss with the injunction lodge of the initial decision with the TSA decision maker. Subpart F. Reserve. Subpart G. Rules, practice, TSA, civil penalty actions. And we're going to cut the tape there.